Good morning. The appellate court for the state of Connecticut is now open and in session. We are conducting this hearing via Microsoft Teams. I'm going to ask that everyone participating in this hearing identify themselves, starting with the judges, and then the appellant, Mr. Wine, and then counsel for the appellee. I'm Judge Alexander.
I'm Judge Suarez. Judge Sheldon.
Mr. Wine.
The appellant, plaintiff Daniel D. Wine.
Good morning, Your Honors. Assistant Attorney General Jacob McChesney appearing for the defendants.
All right. Everyone should have received procedural instructions for this hearing, and I would remind everyone that we conduct ourselves as if we were in the actual courtroom. Are there any questions as to those procedures before we begin this matter? Mr. Wine, any questions?
No, I don't believe so.
Mr. McChesney?
No, Your Honor.
This is the matter of Daniel Wine versus William Mulligan, AC 44261. Each side will be permitted 20 minutes of argument, and Mr. Wine, you may reserve a portion of that time for rebuttal. Would you like to reserve any time for rebuttal?
Yes, I would, please.
How much time?
I'm assuming guesswork, 10 minutes. Of course, if I'm done earlier than that, I'll defer any time towards the end.
Okay, that sounds fine. And with that, I'll start the timer and you may begin.
Okay, I know the rules and regulations of appellate procedures, they frown on long written dissertations or quotes. So I do have something written to kind of go along the guideline to follow, because obviously I'm not a professional attorney. First of all, I'd like to thank you all for allowing me to be here today. The case before this court right now in Wine versus Mulligan, really, this matter has to do with an access to the courts claim. That would be the main topic of this. I'm aware that I had to file a petition for this hearing today, and I'm guessing that it could have been denied, but fortunately it was not. Because according to the defendant's memorandum of law, and this becomes what I believe is the argument in chief in my suit in Wine versus Mulligan, is that it's their belief that I, as a prisoner, only have a constitutional right to challenge my conviction, my sentence, or a constitutional right. This is found on page 5 of their memorandum of dismiss. I strongly disagree with this premise. This brings into question the interpretation of several laws, jurisprudence, and constitutional amendments. In Zorinsky, 87, Connecticut, appellate at 267, and in Santoros versus the Bristol Hospital, 308, Connecticut, 2013, the court held an interpretation of the pleadings in the underlying action presents a question of law and is subject to de novo review on appeal. The Connecticut Practice Book, section 65, states in the relevant part, the court may reverse or modify the decision of the trial court if it determines that the factual findings are clearly erroneous in view of the evidence and pleadings in the whole record, or that the decision was otherwise erroneous in law. I believe that the arguments brought into question by the defendants, that I only have a right to challenge my constitutional conviction or civil rights, basically I'm assuming a 1983 action, are the only things I have a constitutional obligation to argue in a court of law. I believe this brings up a mixed question of law. The defendants chose to take an excerpt from the Lewis versus Casey court, where they state that bounds does not guarantee inmates the wherewithal to transform themselves into litigating engines capable of filing everything from shareholder derivative actions to slip and fall claims. The tools it requires to be provided are those that inmates need to attack their sentences directly or collaterally, and in order to challenge the conditions of their confinement. Impairment of any other litigation capacity is simply one of the incidental and perfectly constitutional consequences of conviction and incarceration. Again, this comes from the Lewis versus Casey court. Lewis versus Casey really put restrictions on the Bounds versus Smith decision. Bounds versus Smith, Lewis versus Casey were all actions filed in the federal court where the prisoners had a right to not exhaust their state remedies. They were able to go directly to the federal court in these situations with questions of their confinement. Generally, as we all know, you have to exhaust state remedies before the federal government will step in and decide what your constitutional rights are. However, the First Amendment to the Constitution allows anybody a right to redress their grievances to government. This is also supported by the Connecticut Constitution, Article 1st, Section 10, where all citizens have a right to civil suit. My argument in this claim and my disagreement with the defendant's argument is that when all the Connecticut general statutes, I believe it's Section 52, are the rules and regulations for civil suits, civil actions in a court of law. Since this is defined and there's rules and regulations, it becomes a state-created liberty interest. I myself, as an inmate, filed in one particular case a visitation application to have visits with my children. The defendants argue that I don't have a right to do that. It's a civil action. Although, being a state-created liberty interest, we even have ILAP, the Inmate Legal Aid Assistance Program, that comes out here, I believe, twice a year and informs inmates on how to file custody papers, how to file visitation papers. They actually have created a state obligation to come out and educate us. In Bounds versus Smith, well, let me back up, I'm sorry. In the civil matters, once I go to the court and I put in a complaint or a petition and pay the fee, or a fee waiver is granted, I then apply for a summons, and that summons is served on each defendant, and a docket number is assigned. In my opinion, that activates the First Amendment. I've had my right to have my grievances heard before a court, and they've accepted that. It becomes an agreement, a contract underneath the Constitution. That activates my 14th Amendment right to have due process in the courtroom. Once they accepted my docket, I have a right to arguments, whether they be written pleadings, briefs, exhibits, whatnot. I don't believe the state has a right to interfere with those pleadings, what have you, just because I'm incarcerated. That would be like the same. That would be the equivalent to a correctional officer coming in here right now and shutting off this camera and this TV monitor and saying that I don't have a constitutional right to argue before this court today because it's a civil matter. It's not a 1983 claim. I find that to be wrong. There's a state-created liberty interest that allows us to argue this in court. Also, the 7th Amendment to the United States Constitution also gives us that same guarantee, where it states, and please just give me 1 second. I was kind of rushed up here. I got here just minutes before you guys came onto the camera, so I didn't have a lot of time to get organized. I might have to come back to this. Basically, I'll summarize. Basically, the 7th Amendment to the United States Constitution says that people have a right to sue in common law court if it's in $20 or more, and that they have a right to trial by jury, and that no United States court will change hear or change the opinion of the decision made in that common law court. So this United States Constitution, to me, gives us authorization. It recognizes that each state has a right to civil actions in the courtroom. So I disagree with, I only have a right to challenge my convictions, sentences, or civil rights disputes. I think that's completely wrong. I have a state-created liberty interest in wishing to do so. Any questions?
Yeah, I do have a question. This is Judge Sheldon. You have filed briefs in this case which reference the Uniform Commercial Code.
Correct.
How did those manage to get to the court without being confiscated in the same fashion as the pleadings that you filed in state court? Do you have any idea?
Okay, that was my next, that was kind of, I was going to expound on that. That's the next section of my argument. They were actually, even in this case before this court in Wine versus Mulligan, the defendants put in a motion to strike. I read the motion to strike. After going back and reviewing my complaint, I felt that I could put more detail in my complaint. And some of the wording in there was kind of ambiguous, could give you two different meanings when I read it. So underneath practice book 10.1, it says that the judge has the authority to ask for a more distinct complaint or arguments in there. I'm summarizing. So I did. I did a opposition to the motion to strike, and I also did an amended petition or a new petition, which stated a little bit more about the facts of the UCC. When I went and asked to have that copied so that I could have a copy to send to the court and to the defendant's counsel, the counselor in my unit confiscated it and said I wasn't allowed to have it. Now, the UCC becomes relevant in the fact that, in my opinion, it's codified under the Connecticut Journal Statutes 42A. It's business law. It's commercial law. There's nothing wrong with using it underneath, in my opinion and my attorney's opinion. My habeas attorney, and I have an attorney in the termination of parental rights. He's actually one that gave me the original document. So in my family, I'm sorry.
Can I just interrupt?
Yes.
You have used your 10 minutes. Do you want to continue right now and I'll just deduct it from the end?
Yeah, I'll finish up on this, and if there's any other questions, we'll decide from there, I guess.
Okay.
So at any rate, the UCC really came up in the visitation application before the court. The family that has my children has custody of them. The Fullers, I have given them a $500 loan in the past for a dental extraction, a bad tooth that the father had. And there's been 3 times, actually 4, but I believe only 3 that I have documented, that I've given them money before I was incarcerated to keep their house out of foreclosure so that their mortgages weren't foreclosed on. I have written IOUs on that, and we have basically handwritten contracts that state UCC arguments in there, or state UCC provisions, rules, and regulations. I actually had an attorney mail me a mechanics lien so that I could try to submit that and recoup some of that money. I wasn't 100% sure a mechanics lien was the proper way to go. It's kind of reading and studying, it might have been more towards a commercial lien. Just a different setup, a different format. I'm not an expert in this stuff. So it was being sent to an attorney to review, to my other attorney, to see what he actually felt was the proper avenue to pursue. Along with court motions to that court in Wine versus Fuller, along with an envelope that was addressed to them, marked privileged legal. Those documents were folded and placed inside it. They were placed in a larger manila envelope that was placed in the mail. They were confiscated, and my complaint in my briefs, I believe, disclosed the rest.
And was this information that you are telling us now brought to the attention of the court in opposition to the state's motion for judgment based upon the granting of the motion to strike?
In this case, yes. Yeah. If you look at pages 1 through 4 of the transcripts, I actually do try to bring it up. I asked for an evidentiary hearing, and this is where this becomes.
You asked for an evidentiary hearing on the motion for judgment? Well,
I went through pages 1 through 4 of the transcripts. I say that they confiscated some motions that I tried to send to the court, and then I tried to ask for say that I needed an evidentiary hearing something to bring before the court. Judge Cobb cut me off and basically said that I couldn't do that. This is a motion to strike. One through four.
Motion to strike. Was there a motion for judgment after the motion for strike to strike?
Yes. Yes, there was.
Did you oppose the motion for judgment?
I believe I put in a motion for re-argument. And this is where it kind of straddles a tightrope for me. Even here today, I asked to be brought before the appellate court. When I put these motions in the mail, when they've been confiscated at the time of asking for copies, whatnot, I keep getting threatened that if I try to put in motions that I'm legitimately arguing in a court, that I could be placed in seg, given a Class A ticket, all kinds of threats. When I'm on video like this, I literally have those same COs making threats standing outside the doorway. That's why I kind of requested to be there personally. Gives me a little more liberal stuff. You kind of feel under threat here. I did try to explain that on pages 1 through 4 of the transcripts during that hearing. It didn't go farther than that. There's no way I could ever put in an amended complaint because DOC wasn't having it. They were not allowing it. What I put in was all that they would approve of and allowed to go out of this building. And that goes back to Ex parte Hall, where the Supreme Court made a decision that this is the executive branch of government. It can't oversee the judicial branch of government. They don't have a right to tell what I can or cannot argue in a court of law.
Are you suggesting, sir, that after the motion to strike was granted, you attempted to file an amended complaint, an amended petition?
I attempted to file an amended petition before that, and that's even in my briefs. I attempted to file an amended petition right after I read the motion to strike, the memorandum of law put out by Attorney McChesney. I tried to do that wait a minute. Sorry, I'm trying not to burn up all my time here.
Hey, what? Don't waste your time now. You can look that up and then use your rebuttal and let me know then.
Thank you. I'll defer my time.
All right, Mr. Wine, you'll have still about 5 minutes left for rebuttal. So again, reorganize your thoughts. And again, I just want to confirm you are the only person in that hearing room, correct?
Correct, but first of all, the courts are public. But the thing is you can hear in the room next door exactly what's going on. Anybody sitting on this other side of this room may as well be in this room. There may as well not even be a wall or partition there. Same with these 2 outer doors. I have COs outside of each.
Okay, but you have told us everything you need to tell us on this record, correct?
Yeah, I believe so. Like the only thing I want to clarify is that I did try to talk about that during the hearing. Pages 1 through 4 show that, but again, I'm under threat. If I say or put certain things in, they're saying, hey, you're going to seg. And no, I'm able to articulate everything here comfortably today. It's the appellate court. You're a higher court, and I feel like if there is any repercussions, it's on record that I haven't done anything crazy or wrong. I'm trying to be respectful, and I'm assuming that I have some backing from the judiciary if that became the case.
That's how we conduct these proceedings. So that's why
I try to maintain professional too. I understand that you guys run into problems with inmates and prisoners, and I litigate a lot in courts, federal and state. I've become somewhat proficient at it, and I don't try to do anything unreasonable.
All right. We're going to hear from Mr. McChesney. He has up to 20 minutes, and then we'll go back to you for the rebuttal. Mr. McChesney.
Thank you very much.
Good morning, Your Honors, and may it please the court. I am Assistant Attorney General Jacob McChesney, as I mentioned at the beginning. I'm here representing the various defendants in this civil rights action, as you know, filed by the pro se plaintiff, currently incarcerated with the Department of Correction. This was a complaint alleging violation of his rights under the United States Constitution, specifically interference with his access to courts and his equal protection rights. This matter before this court is the court's granting of the defendant's motion to strike, and the specifically the propriety of that granting of the motion to strike. the aforementioned claims, both access to courts and equal protection. First, just to sort of pick up on the questioning by Judge Sheldon, my recollection of the procedural process here, we had filed our motion to strike. That was granted. He filed a document, I think it was untimely, which he titled an amended complaint, but upon review of it, it contained legal argument, and it was, as he referred to, a motion for reconsideration. We had objected to that, and we also filed a motion for judgment. The court denied the reconsideration, and as he had not filed an amended complaint, the court granted judgment, and there was no following motions by the plaintiff or attempt to file an amended complaint thereafter. I want to just again note what we're on appeal here for. It's a motion to strike and the court's granting of that motion to strike of these specific claims. And I think it's important to go through what he's actually alleged in the four corners of the complaint, as that's what the trial court was looking to in determining whether or not it was appropriate to strike those claims. He first alleged that this was mailed to a third party, his sister, not to an attorney, not even to the court. He alleged that he put certain documents he had already filed with the court into this envelope to a third party. And he references in his complaint 3 quote unquote legal actions, only 2 of which are actually litigation matters. One was a civil family matter in which, as he noted, he had filed an application for visitation. It was, as he alleged in his complaint, based on his belief that the UCC provided him, I guess, property rights over the children, and based on that, and also another action that was against a therapist, alleging violation of copyright and trademark, again, related to the UCC. That's what he alleged in his complaint. So we had filed a motion to strike, and I'll focus mostly on the access to courts claim, as the plaintiff did in his argument. We had filed a motion to strike because he hadn't met the basic elements necessary for those types of claims.
Sure, Mr. McChesney, just
yes, Your Honor.
direct yourself to this. You make a big deal in your brief about how these are frivolous arguments and that there's no basis for these claims, a copyright claim on the one hand, or any kind of claim under the UCC. That's not what you argued in your motion to strike. And Judge Cobb merely said she was granting this for the reasons that you had stated in your brief. We can't reach those arguments in deciding to affirm this decision, can we? Because that's not the basis upon which Judge Cobb even could have decided the issue.
Well, Your Honor, I believe we did reference the requirement of an actual injury to a non-frivolous claim. I do know that we referenced
but you didn't argue the non-frivolous nature of it in your motion to strike, is my point. So that, to try to get an affirmance, Judge Cobb did us no favors by not describing what her basis for ruling is. But I suppose she did describe it by way of reference to what you wrote. And you didn't make the argument you made on appeal when you were before the trial court, did you?
Well, I don't recall if it had been elaborated on the frivolous nature of it because it was similar to UCC filings, but we certainly argued that there was no actual injury to a non-frivolous claim.
That I understand, and I'd like to have you address that specific point. But in terms of upholding this, for us to indulge the argument you've made in your brief about the frivolousness of this would be for us to reach an alternative basis for supporting the judge's decision on the motion to strike, which you never argued. And because you didn't argue it, because of the way she wrote her decision, there's no way we can rely upon that, can we? Legally.
Well, Your Honor, I'm not sure I agree that it wasn't within the confines of what we argued, but I will acknowledge, Your Honor.
If it was not, then you can't rely upon it, correct? In light of the way she decided it.
I was going to say, Your Honor, in light of fairness principles, I'm not sure if this court would address it, but I also don't think that it's a necessary component of affirming the granting of the motion to strike, Your Honor.
Right.
And I can go into the actual injury prong, which I think is the strongest deficiency in his complaint. Essentially, it requires that he allege some type of actual injury to its claims. First, I'll know, as I just noted, this is not a filing with the court. This is a alleged to be mail that he sent to a third party, his sister. And in fact, if you review his complaint, he's alleging he's already filed these documents and they're being adjudicated with the court. So from his complaint, he's not alleging interference with anything that's actually being filed with the court. And I'll also point out he doesn't allege that there was actually any harm that occurred to these actions based on this alleged interference. And in fact, if you look at the dockets for both of these matters, they were being actively litigated at that time. And I think the family matter is still being actively litigated. And the action against the therapist only recently had summary judgment granted against.
We can't consider those things in support of the judge's decision on a motion to strike, correct? But we're bound.
Well, Your Honor, it would require reviewing. The court could have obviously reviewed the docket. But I would point out, if you look just to the.
What do you mean by that? The judge didn't say she did that.
No, Your Honor. And I would say if you look to the four corners of the complaint, which you should be looking to for a motion to strike, he has not alleged that. I merely added as additional information. But if you do look to the four corners of the complaint, there's no actual injury that's alleged here by the plaintiff, and that is an essential element here for an action to its claim. And the only other point I'll briefly address is I do want to dispute the plaintiff's indication that we're alleging here. He has no recourse under the Constitution. I'm not sure what other claims he could try to pursue, but our only argument here is he presented an access to courts claim. And if you look to the history of that claim, you look to Lewis v. Casey, the United States Supreme Court recognizing an access to courts claim under the U.S. Constitution. It's recognizing in the context of these actions that are challenging convictions or sentences, either directly or collaterally, obviously direct appeal or a habeas action, or some other type of action that's challenging their basic constitutional rights.
Mr. McChesney, the question I have for you is this. That whole concept of limiting the right to challenge constitutional rights to those matters derives its origins from Bounds, correct? Where Bounds, there was an effort to say that there was a necessity of having either a lawyer or a prison library for these various claims, correct?
And I think that is a correct representation of Bounds, Your Honor. And the most common circumstance it pops up in is access to certain resources like library. But there's I don't read Lewis v. Casey as indicating any difference in the type of interference that's alleged.
Well, but sir, honestly, it makes no sense to me. If you could imagine that correctional officers could take a look at legal mail and simply throw it away or put it in the circular file or hide it in some fashion and not deliver it to court, where someone happened to be asserting their rights as a parent to pursue visitation when in fact they have custody, then you're suggesting that there is complete license on the part of correctional people to interfere with that because it has to do with a different kind of constitutional right. And I don't understand that. Is that the argument you're making? They could do anything they wanted to interfere? Not just not providing a lawyer, which I understand, or not providing a library, which I also understand, but actually affirmatively interfering with the ability to make filings in a court in pursuit of rights that have not been lost by virtue of incarceration.
And no, Your Honor, I appreciate the opportunity to clarify that. That's certainly not what I'm not trying to suggest the DOC has carte blanche the ability without recourse to interfere with mail simply because it does not have to do with one of these types of claims. I'll explain that in a moment. All I'm trying to argue and put forth here is that access to courts as a separate constitutional claim is a clearly understood claim under Lewis v. Casey and et cetera to apply to those types of claims. So I'm not trying to argue that he does not have some other constitutional recourse if he wants to try to file some other type of claim. And I'll also point out interfering with mail would be a violation of the administrative directives of DOC as well. They're not, if it's mailed to an attorney, mailed to a court that's marked as privileged, they don't even have the under the AD to the right to
Okay,
review
well,
that.
Mr. McChesney, let me just say this then. What you're telling us is that you've responded to the label that you think he's put on it. But if we deal with the substance of the claim that he's presenting, you might call it by some other name, but the substance of the claim is that he has a right to pursue, as a parent who still has parental rights, after the visitation with his child. And if the Department of Corrections is interfering with his ability to exercise that right, I don't mean by not giving him a library or not giving him a lawyer, but I mean by parsing through his mail and pulling things out and not putting him into a court, not sending them in, then it seems to me that the substance of a constitutional right, whatever its name is being violated. So I'd like to ask, I mean, that's my suggestion to you. Do you agree with that?
Well, Your Honor, I think that we're in the context of a motion to strike and reviewing the sufficiency of the allegations that he's made, and that's the context of the argument that we're making here in the court's decision. So, I think there's a few different issues in what you presented, Your Honor. First and foremost, when we're talking about access to courts, I understand that it's a label, but it's the label that the plaintiff opted to put on the claim he was trying to pursue. And especially in the context of a motion to strike and notice principles and pleading requirements, the defendant is entitled to take the plaintiff at his word of the type of claim that he's pursuing. So, and he has, I will note, he has recourse after a granting of a motion to strike if he wants to try to present some other claim. But I did want to just briefly address, again, I'm not trying to suggest that DOC has the right to just go in and obstruct legal mail or obstruct any mail, really. I'm simply trying to put forth that under Lewis v. Casey and surrounding case law, it's recognizing that there's usually a different context it comes up in. The recognition is nevertheless that when we're talking about access to courts, it's interference with those types of cases. One thing I do want to recognize, Your Honor, because I know there's a concern with the family nature of one of these litigation actions. The other one, I think, is clearly a civil matter that he's pursuing as a civil person. But I will recognize the other one does fall within the context of the family relationship. I'm sure that this court's familiar with cases, for instance, in the context of termination of parental rights. And there is some constitutional issues at play there. I think that they do have the right to counsel in those types of actions, certainly in Connecticut. There's a case, I know, a U.S. Supreme Court case, I think it's MLB versus SLJ, is a U.S. Supreme Court case which was discussing parental rights. But in the context of that, one thing I will say that I think is a distinguishing factor here, it's not just that it's a family unit relationship that's being addressed that makes it a fundamental or basic constitutional right. When it was parental rights in the US Supreme Court, there was a lot of discussion of it being a government action that was permanently and irrevocably revocating a sacred right that is between a parent and a child. So I do think we're in a, yes, Your Honor.
It's my understanding that this family action is pending, that he was making these submissions for, is not a termination of parental rights action. Am I wrong?
No, Your Honor. And I was going to mention that what he's alleging here, it's not a termination of parental rights action. It's not by the government. It's him with another private individual. And it's not the issues that were in the termination of parental rights genre of cases is not an issue here. It's not a permanent revocation. It's not irreversible. It's not with the government. And I don't think that you can separate out the nature of what he was trying to pursue here from this question of whether it fell within these types of cases that fall within an access to courts claim, because from what he clearly alleged here, it's not even, he's pursuing a visitation application based on misapplication of the UCC. So what he's essentially trying to litigate here is his rights he believes he has under the Uniform Commercial Code. So I recognize that there's a nature of this one litigation that's family oriented, but for the various reasons I mentioned, I think it's distinguishable from things like a termination of parental rights case. And I'll even know, to the extent that this court's uncomfortable with that case in particular and finding that it certainly doesn't fall within one of these recognized access to courts claim, he still has the insurmountable issue of an actual injury in the complaint, and that would more than support the granting of the strike motion to strike here, Your Honor.
And your argument as presented in support of the motion to strike on that subject was what?
I'm sorry, Your Honor?
The argument that you presented in your memorandum in support of the motion to strike, which we ordinarily wouldn't look at, but here because Judge Cobb specifically relied upon that as the basis for her decision. What was your specific argument there?
Well, I do know it followed the basic, I know that there was some discussion of whether we got into the frivolous issue, but it followed the basic framework of the argument that we've presented here, i.e. that access to courts requires that it be in particular types of cases. Neither of these cases fell within that, and also that he demonstrate an actual injury, which the nature of the claims he was presenting here and what he presented in his case, there was no actual injury. And then I can address the equal protection issue.
No, just on the actual injury claim, though, the point there is simply that nothing has been alleged to suggest that his ability to proceed has been materially harmed by anything that DOC did or any of the particular employees mentioned in the lawsuit did, correct?
That is the main substance of the actual injury.
Okay.
On the issues of equal protection and personal involvement, I'm willing to rest on our brief unless there are some questions from the court on those specific issues. Then with no other questions, Your Honors, in sum, based on the allegations that were contained in the four corners of the complaint, we think that the lower court's decision to strike these claims was more than supported by the absence of these essential allegations in his complaint, and we'd ask that this court affirm the lower court's decision to strike it. Thank you.
Thank you, Mr. McChesney. And let me just set my timer again. And Mr. Wine, as I indicated earlier, you do have 5 minutes for your rebuttal.
Thank you. I'll try to make this quick then. So to rebut these claims, first of all, to address Judge Sheldon, I'm sorry, I'm horrible with names. His question before I finished, I did attempt to file a new petition in response to the motion to strike on 10/2/19. After Mr. McChesney had filed his memorandum of law to motion to strike. Now, Attorney McChesney does argue in his brief, I believe it's at page 4, that these arguments should only be within the confinements of the four corners of my complaint. As I previously stated, that the defendant's rebuttal brings up questions of law. Basically, do I only have a right to challenge my sentence, civil rights, or conditions of confinement? And he presents several cases that support that in my opinion are wrong. The federal courts don't generally regulate state courts. You have to exhaust your state remedies before you can even go to a federal court. In each of the cases, Ex parte, Hall, Bounds, Lewis versus Casey, there was civil rights deprivations. It was a lack of access to the courts is the overall argument. The federal government made rules and regulations over that. This isn't the case before this judiciary today. The argument here is that I'm arguing state claims, civil claims in state court, and Connecticut general statutes give me a right to access to the courts. That's what causes the access to the courts claim. Now, as far as the personal injury, I'll rely on my briefs, but in one portion I did put in my brief that Cody versus Weber, where the 8th Circuit found that the DOC got an upper hand by reading the legal motions of a prisoner, and that gave him an unfair advantage, and that was considered an injury. I do have another one. I was trying to find it in my brief that says that the confiscation of any papers interferes with due process, and that is an actual injury. Now, in each of the cases that were discussed before the court today, my visitation application, first of all, I'll argue that they're saying that the UCC, I'm arguing all this crazy stuff. that's, the briefs like that are what put me in a position of threat under here by DOC. They're absurd decisions. Second of all, that the confiscation is an injury in and of itself because I cannot properly prosecute these matters. I can't argue them. The courts are taking my motions out of the mail. Literally, this is why at page 4, Attorney McChesney argues that you should not take into consideration my appendix at page A37 through A41, because at A39, literally, I'm sorry, not A39, A37 literally shows in writing a receipt given to me by DOC where they confiscated my amended petition, my motion to the court in a matter against them, and would not allow me to send it in so that I could not competently argue what should have been argued in that court and not before this court today, because they weren't allowed to receive the motion. How is that not an injury? That has reoccurred over and over in my other case. Now, my case against Wine versus Barnes, again, I couldn't prosecute the matters. I was asked at the time of judgment if I had proof of a trust that I have. I told if I submitted it, I told her no. I couldn't submit it because DOC would not allow me to submit it, and it's legal paperwork. It's drawn up by an attorney. But according to them, it makes the claims to UCC. That matter was dismissed, I feel, because I couldn't present the exhibits or the evidence that the court felt was that the court wanted to see. That's like, you're not receiving my brief in this matter today. DOC is confiscating one of my briefs and saying, no, you can't mail that. That is an injury. That's interfering with my access to the court. That's impeding, frustrating. That's purposely interfering with my access to the court. That is a constitutional right. Once the court's accepted and docketed my complaint or my pleading to the court, the executive branch of government doesn't have a right to interfere and come in and take my complaints. That was decided in Ex parte versus Hall. They don't have a right to tell me what I can or cannot draft or argue in the court of law. I'm not threatening any state representatives like the Sovereign Citizens Group. I didn't file liens against wardens or governors or you, the judges on the panel. That's absurd. That's ridiculous. And you want to talk about conclusory allegations in the complaint. Well, I'd like the conclusory allegations in the state's brief. I find this unfair.
Your time is up.
And the rest I will have my brief, and thank you for your time.
You're very welcome. We will take this matter under advisement. We will stand in recess and continue our other matters momentarily.